So first of all, thank you so much for inviting me, and this is really spectacular. I'm really excited to be here talking with all of you about AI liability. Usually when I do these type of presentations, I have to spend a couple of minutes explaining AI. Hopefully I will try to fight the urge to do it, given that this room knows about this more than the average person. So as Colin said, kind of laying the land for perspectives on AI liability, because both of us working in the sphere of insurance and in the context of AI, it will undoubtedly go that direction, but hopefully we will make you think and feel how insurance liability is important here. We kind of disagree about a lot, so hopefully it will be interesting in a very friendly way, obviously. So, as setting up the stage, when you think about AI liability spectrum, and that's something that I think a lot of people in this room have very different opinions about, which is, I think is great. We can go over to the liability immunity part, or some sort of safe harbors saying that as long as you do X, Y, and Z, you will not be held liable, and we have a push towards this right now, as I feel it, because we want to protect innovation, we want to make sure that innovation is thriving and not just surviving. And the action plan that is currently going on in the US is kind of focusing on this, given the narrative of the race, and I think that there are a lot of people who would be very happy to find themselves on that side of the spectrum. Going a little bit towards the middle, we have negligence, the reasonable computer, the reasonable robot, and what do we do with that? And I know a lot of people in the room are thinking about this and advocate for this. I disagree with you, and we will talk about this obviously more in depth. Agency law, which is a big core of the paper that was just presented, and this is something that I think is the best approach at the moment, and I'm going to talk a little bit about that as well. Products liability, going all the way to strict liability. Again, if you disagree even with the spectrum itself, that also makes sense. People see this in different ways. Products liability is something that a lot of scholars, I think, are advocating for. I don't really see AI merely as a product at the moment, but it might be a good starting point. Going all the way to strict liability, which I think, because of the respondents appear and the agency law, makes a little bit more sense, given the way that the AI industry is currently structured, and given how we as users and consumers usually don't have a lot of influence or expertise or resources to know what we're dealing with. It could be potentially dangerous, or implement safety mechanisms, unlike the analogy of the car, the automobile, which is something that I use a lot when I talk about AI, which we can, as the drivers, we can do something at least to try to mitigate potential harms. So I will talk a little bit about agency law, given that I think this is the right analogy at the moment, the correct, not correct, but the most suitable lens when we talk about AI liability. I'm not married to this in any way. I was publishing specifically this about respondents appear in 2019. A lot has happened since, generative AI, as well as agentic AI. I do think there's room for flexibility and change. I do not think we need to reinvent AI tort liability. I think the current mechanisms in place can do a very good job. And just like other emerging technologies that came into the world, and everyone were freaking out saying that the tort system should completely alter itself, we survived the Industrial Revolution, we survived the internet. We are currently focusing on AI. The quantum is coming next. I think that the bases are something that we can utilize, especially that it's already happening. AI is already on the road, so to speak. It's already being used by a lot of people who don't really understand what it does, and ChatGPT has contributed tremendously to this trend. So my analogy is like the car is already out there, but we have no roads, we have no traffic signs, or we have them, but they are very minimized, or they are already there because they were used for horses before that. So we need to try to step up, and giving what we have is something that I think makes sense. So the liability regimes, as I just mentioned, talking about strict liability, ultra-hazardous activities, some scholars talk about AI as such. I don't think that's necessarily the correct lens. Maybe it is in this moment. When hot air balloons first started to be used, they were considered ultra-hazardous activities. They are not at the moment because we have enough safety mechanisms to figure out what to do in order to make them safe. Think about airplanes. The first person who got on an airplane must have been crazy. And so AI kind of goes into the same lens. But AI should be something that will help us mitigate risk and not contribute to it. So ultra-hazardous activities seems like a bit of a stretch. Products liability and its defects, which I think can be useful at the moment when we are still initially integrating AI, but might change as I think design defect or manufacturing defect will probably release AI companies from liability for the most part. Wild animals, as well as domesticated animals, this presentation is built on an article I wrote talking about different analogies, and the next couple of slides also talk about this. So some people like to talk about AI as dogs, and we actually have robo-dogs and stuff like that, or bears, because they are unpredictable. I'm not sure if the lens that we have for liability right now makes that much sense, because AI is not like an animal. It has different features. And that's why the focus on a principal agent is something that makes more sense, in my opinion. We talked about safe harbor and immunity. A lot of people talking about ex ante in the form of FDA for algorithms, sort of safe harbor. Negligence, which is, we have a specific panel on this, so I'm not going to go too deep into it, but the legal nexus of factual and legal, as well as the reasonable standards and benchmarks, which can be very difficult and might not be very appropriate or suitable at the moment, as well as damages and agency law, which is what I'm advocating for. So the legal analogies I review are property, focusing on products, animals, and slaves, which is something that is kind of taboo, but when we talk about duty barriers as well as right barriers, and Thomas talked about in ancient Greece what happened in that context, so it is ongoing, and the analogy does kind of make sense, but it's not as neat, I would say, as the principal-agent relationship. Electronic persons, quasi-persons, kids, AI personhood, which is kind of not far-fetched, but it's a long stretch at the moment, probably, thinking about AI as kids, and there were a lot of research saying that AI right now has a mental capability of a 5-year-old. We have different agenda when we raise our kids, I hope so, and we want to make sure that they are contributing members in our society, and most of the time I, as their parent, will be held liable for what they're doing, so I have extra incentive, and also I have like an emotional responsibility towards them. I made the decision usually to bring them into this world. It's not necessarily the connection I think is suitable in the context of AI. And then agency law, which strikes me as the best balancing point at the moment, because when we have a principle that they know that they will be held liable, they have some sort of certainty, which I think is a big thing when we talk about big companies, and they can proactively take measurements in order to make sure that their AI is doing some sort of things that make more sense, mitigating the risks, and incentivize them to take insurance or train them a little bit longer before they send them into the world. I also talk about this in an industry level, so thinking about the aviation industry, which in the beginning had like very broad protection from liability because we wanted to encourage it. Right now we're seeing kind of a decline in safety of airplanes. Knock on wood, we are all going on a plane in the next couple of days. But I don't think it's necessarily the same or similar enough. We also talked about the vaccination industry. We have some sort of immunity, and the Supreme Court talked about this, and the dissent talked about the lack of incentives to do better. So as I don't think the majority of us will think about AI benefiting society the same way as vaccination does. So creating an immunity is not something that I think makes sense. And going away from legal analogies, which obviously legal analogies has their flaws, it will never be the same, but we as humans and legal scholars are usually looking for something that is similar enough to build upon, and AI is the long list of analogies that are people currently talking about shows that it's everywhere, and tailoring the specific analogy and eventually maybe going into something that is not an analogy anymore will take time, resources, and understanding the technology itself, whether it's similar or different enough from something we know, or maybe eventually be its own kind of category. So thinking specifically about the respondent superior, about the principal-agent alignment, which I think at the moment makes sense. I think the shift to agentic AI, I don't think that the term agentic AI was chosen from a legal perspective, and there's a lot to say about terminology, but I think it's outside of the scope of this specific panel. But it did kind of push us into this, these are agents. Whose agents are these? Like, who is the principal? And I have a paper on this, and I agree with Thomas that this is a big problem with this infrastructure or structure of a legal doctrine, which is solvable, and we have several and joint liability, which also works if we have multiple principles, so I don't think necessarily that needs to be a big hurdle for this implementation. I do like to focus right now, because AI is kind of new, especially with people who are kind of approaching it for the first time, controlling the levels of activities rather than the duty of care via strict liability makes more sense for me. Thinking twice before using it for mundane things or things that will just create liability with no deep disregard is something that I think because this is a nascent technology, which is really new, and we've seen throughout history that strict liability usually is the first to follow, and once the technology makes sense for us a little bit more and has some sort of safety mechanism in place, we kind of shift into negligence. I don't think this will be different in this specific scenario. So I think this is already kind of what I gathered. I do want to address the chilling effect, the stifling innovation, which keeps on coming back whenever people talk about strict liability, because obviously companies will pay a lot of money, the big companies as well as the smaller ones, and we do want to encourage innovation. But if we have no liability or some sort of immunity, that will also, and lack of incentives, I think that will also lead to problematic results. And I like this, the innovation is never stifled, it is only redirected internally, and external forces maybe make the AI better before you put it out there. That's something that will redirect the forces themselves. Deciding on a liability regime is hard, and it might shift, just like I talked about strict liability versus negligent. And I already mentioned there's a limitation to using legal analogies. Right now, I think what the respondents appear makes sense. It's not going to be forever. I'm just going to take a minute before Dan will probably go deeper into this. I am not a spokesperson for insurance companies, but I do believe in their ability to offer liability policies and make sure companies are doing better in real world. Insurance companies are situated to see the claims that are coming in and tell us what we can do better. And they do have some sort of interest to do it because they don't want to reimburse us when we get harm, and we don't want to get harmed because we're humans and we are risk averse. So I had a couple of articles focusing on this. The recent one was empirical work talking with companies offering insurance policies specifically geared towards AI. And there's Municre, there's Vouch, there's Armilla AI, Cover Your AI, which I think is located in the UK. This is AI Shelter, Realm, and Pseudo. All of these are companies operating in the sphere, and they are they believe that they will have the opportunity and ability to make AI safer for us. This is just for a couple of days ago. We can see this happening already in the UK, some sort of a collaboration to have framework in place at least until the regulatory landscape becomes a little bit more clear, because we all need and want some sort of risk hedging mechanism in the background. So this is my kind of positive view of this. I know Dan will show us a broader picture. And I think AI liability will progress, will change, and shifting the responsibility from one entity to another will probably change because it has done so across emerging technologies through history, and I'm excited to see what happens next. Thank you.
What I'm going to talk about actually is a paper that I am developing that's under development right now. And the basic goal of this paper is to think about how insurance plays into how we should think about AI liability. It's joint work with Josephine Wolf, and we're hoping to have a draft out soon. So if you're interested, please let me know and we'll send you one. So let's just start off with this. Liability is often thought of as an AI regulatory strategy, and there are a lot of proponents of this view. And the basic idea is that a major purpose and goal of liability is to affect behavior by deterrent, right? That's BPL, that's negligence. And it's thought that liability is this great tool for regulating AI because it's flexible, it's adaptive, it can deal with new technologies it has in the past. And so that really is this, I would say, this emerging view, especially in the US. Now, what's often sort of skated over is the fact that the extent to which liability influences behavior and has an incentive effect depends critically on liability insurance. Why is that? Well, the first thing to understand, they're going to yell at me for not using the mic, so I can see it already and anticipate. So the first thing to understand about why liability insurance is crucial for understanding incentives is that most firms are going to be insured against the risk of liability. In fact, most firms are already insured against the risk of liability by the fact that they have D&O policies, cyber insurance policies, E&O policies, CGL policies. Most of those policies do not have carve-out for AI risk, and so they provide what's called silent AI coverage. Now, it may be eventually they start excluding AI risk, in which case, as Anat mentioned, there are going to be firms offering AI-specific policies, and they're already doing it. So the first thing to recognize is, if you have a liability system, most people who are potentially liable are not going to be paying judgments. Instead, they're going to have liability insurance to protect them. That only becomes more important when you recognize that many potential folks who are going to be liable are going to be judgment-proof, because they're going to be startups. And by the way, even for those folks who don't have insurance, right, a lot of times you might think, well, they're not going to know what liability might be or how to respond. So understanding liability insurance is absolutely 100% crucial to understanding the actual potential of liability to have the regulatory effects that are so lauded in the literature. Now, the fact of the matter is that there's actually a big literature on regulating by insurance. And at the end of the day, it has a pretty mixed track record when you look at the data here. So it is certainly true that in some domains, insurers are great regulators. Think about workers' comp. I think that's probably the best example. Insurers have done great work to reduce workplace injuries. They also did great work to reduce fires. Why? They can price risk, and that means you have an incentive to reduce your risk because you pay lower premiums. Oh, and by the way, they can also actually teach you how to do things better because they want risks to be lower. And so workers' comp insurers are great at actually telling employers how to reduce workplace injuries. Everyone wear a hard hat at the construction site. Make sure when you're operating that forklift that you have, a beeping sound so everyone knows about it. Great. So there's some domains which insurers work great, both in pricing risk and in producing information that can help limit risk. But the fact of the matter is the track record is not perfect. And there have been a number of domains in which there are very strong evidence that insurers have not actually reduced risk. Instead, there has been something called a moral hazard, which I'm sure many of you know what it is. It's the idea that once you have insurance, you're less careful because what the heck, it's the insurer paying for it. And in many domains, insurers don't actually price risk in a way to drive reductions in accidents. And in many domains, they don't produce useful information. There's actually some great literature on this in the context of directors and officers insurance, where we've seen actually that a lot of directors, and some of you may know this, Tom Baker and Sean Griffith have a number of very important articles in the corporate and securities law domain showing how D&O insurers don't actually end up driving better corporate governance for a variety of complicated reasons. So the first thing you should understand is if someone's just throwing out insurance to you and saying, oh yes, liability insurance is super important, but they price risk, that is not an answer. You need to actually go into the mechanics of insurance. Now to do that, we can't figure out how AI insurance is going to work because really we have not had much AI liability. But what have we had that's very close? What we've had is cyber insurance. And in fact, in the early 2000s, you heard a real chorus of people saying, cyber insurance is going to solve our cybersecurity problems. In fact, that has been the dominant regulatory approach of the US over the last 15 years. Promote cyber insurance. And cyber insurers will price the risk of cyber accidents, and they will research how to promote cyber security, and we will not need any heavy-handed bureaucratic regulation because this stuff is too complicated for regulation. It moves too quickly and no one understands it. Sound familiar, right? So that was the approach. But if you actually look at the track record of that approach, it is dismal. In general, there is very strong empirical evidence that cyber insurers do not price risk well. How do they price risk? They look at your size, they measure your assets, and they look at the sector you're in. And that is pretty much it, folks. Now, what types of incentives does that create? Oh, I'll stop being in the healthcare sector so my insurance premiums are lower? Oh, I'll grow less so my premiums are lower? No. In fact, it sends the message that being safer doesn't reduce your premium, so why do it? Cyber insurers don't actually raise your rates when you have a cybersecurity incident. You want to know why? Because if you have a cybersecurity incident, you're less likely to have one in the future because you take all these measures because your vulnerabilities have been exposed and you're safer. And if an insurer tries to raise your premiums, you'll switch insurers. So that great technique of what's called experience rating, if you have lots of accidents, we'll raise your premiums and that creates good incentives for you, it doesn't happen. Cyber insurers have not promoted great new innovations in cybersecurity. Sometimes they partner with cyber firms. But it turns out that it's really hard to improve cybersecurity. It's not like wear a safety hat or have a ringing bell on your forklift. It's like reconfigure your network, and your particular network is structured in this very complex way, and we need to figure out, based on your particular scenarios, how to deal with it. And it turns out that insurers who offer year-long insurance policies do not have the incentives to develop really complex consulting services about how to improve your cybersecurity. So they don't do it. Instead, and again, there have been books written on this stuff, okay? One of my colleague, Josephine Wolf, wrote a great book on this. She's not the only one. What they do is they basically promote like symbolic compliance. You all know this, right? You go to the compliance and you're like, don't do this, it's bad. And it doesn't affect anyone's behavior. Everyone's bored. No one's listening. And we're like, well, now we checked that box. Now we're less likely to be sued. Great. But it doesn't actually reduce the likelihood of the accident. So there's a lot more that can be said here. As I said, another important point here actually to highlight is that insurers that have tried to offer intrusive cybersecurity measures have failed. Why? Because no one wants to buy insurance from them. It's a hassle. It's a pain. You don't want your insurer coming in and telling you how to work your cybersecurity and making your life more difficult and implementing multi-factor authentication when you just want to get to check your email. It's a pain. Okay? And if you're going to have an insurer that does that, then your broker is going to say, let's go to this other insurer. And by the way, cyber insurers were making a lot of money in those early years because there weren't a lot of claims and it was a growing thing. Everyone wanted to be there. So everyone wanted to sell you insurance. So they were selling cut rate insurance. And they especially wanted to do that because they wanted at least a little bit of historic data. Because they didn't have any historic data because cybersecurity incidents were new. So they didn't know how to price it, which only made risk-based pricing worse. So what happened in the cybersecurity space? Pretty much in 2022, people started to realize, gee, we have more cybersecurity problems than we've ever had. And this whole cyber insurance thing isn't working. Maybe we should regulate this industry. And they implemented regulations that had been proposed 15 years earlier on a sector-by-sector basis, like, gee, maybe encrypt your data in certain types of data. Maybe have multi-factor authentication, right? Basic, simple things that had been proposed in 2010, but not implemented because of the promise of cybersecurity. All right, let's now start thinking about AI. In AI, we have continually shifting risks, continually shifting technology. We have no historic track record, just like with cyber insurance. We have no standardization of AI safety data across the industry, which means it's very hard to predict accidents and safety problems. So the first thing to understand is we don't have a historic track record, just like we didn't have one in cyber insurance, which was part of the difficulty of pricing accurately. In the AI setting, safety is entirely or very heavily firm specific. If I just had the wear your safety hat version of AI safety, that wouldn't do very much, would it? Right? AI safety has to be customized to your firm, to the AI tools you're using, to the ways in which you're using them, to the audits that you're performing, to the risks that are particular to you. And so insurers don't just have some easy solution they can push out. In order for insurers to teach firms how to do AI safety, that's really difficult, hard work, and they don't have the incentive to do that if they're only providing year-long coverage. Nor do they have the expertise, frankly. Do they have an incentive to broadly research and disseminate this information? Well, I'll tell you this. Firms that are using AI are not going to welcome insurer intrusions upon their operations. AI is a potential, not sort of just risk mitigation center, it's a potential profit center. And so people who are buying insurance are not going to want insurance that intrudes on their operations. Insurers, meanwhile, are going to want to grow this business early on because it will be a profit center. It will be a new form of coverage, and they won't have data, and they'll want to get that data. The exact same dynamics we saw in the cyber insurance setting. And by the way, the technical expertise you need to actually implement AI safety is expensive, which makes it all the more unlikely that insurers are going to be able to implement that well. It's also not entirely clear that insurers are going to have the right incentives to promote AI safety. Because at the end of the day, they only care about liability. And so things like promoting symbolic compliance, which we've seen a lot in the cyber insurance sphere, I guarantee you that will happen if we have a robust AI insurance domain, where we're getting these trainings that are useless, that don't actually move the ball forward, but that are meant to shield the company from liability. We'll also probably see other things, like having policyholders having contracts that limit their liability exposure. Again, not about AI safety per se, because that's hard, but measures to limit liability for AI risk. So when we take stock of this, here's where we land in my view. I do not believe that liability has a significant potential to operate as a regulatory force for most firms. If we rely on liability alone, we will have liability insurers not pricing that risk well, and we will have firms not caring about liability because they'll be insured against it. It doesn't mean there's not a role for liability, and it also doesn't mean that liability can't regulate anything. It probably can have some effects in some settings, right? But in my mind, the track record is not one to be thought of as promising in the cyberspace. And so that leads me to the conclusion that if we really want to promote AI safety, we can't just rely on the silver bullet of liability and say, we'll figure it out later using tort law. We need to do the ex-ante regulation. Now, I wish I knew how to do it, but I've heard there's some folks in the room who have ideas on that front. And I'm here to tell you that if we don't figure out how to regulate this effectively ex-ante, and we just rely on an ex-post liability-oriented approach, we're not going to end up, we're going to end up in the same place we ended up in cyber insurance, where maybe 15 years down the road, after all these problems happen, we'll end up doing what we should have done 10 or 15 years earlier. And I think that would be a shame. So as I mentioned, the paper's nearly there. I'm hoping it will be there very soon. I'm happy to share it with you. But for now, I'm looking forward to the discussion.